Welcome back to the People's Law School. You know, we've been doing this about 12 years, I guess, in Huntsville, and this year we've decided to produce it and televise it statewide, and have had amazing response. The word has gone out that we of the Law School, People's Law School Selection Committee, have been able to round up the best lawyers in Alabama. And in Steve Henniger, our next speaker, we've been able to round up one of the best lawyers in America. Steve Henniger graduated from the University of Illinois and then came to Birmingham, Alabama, and he graduated summa cum laude from Cumberland School of Law. He's been a trial lawyer in Birmingham, Alabama for many years, and he's a member of the National Order of the Barristers. And as I said, he has been selected in some publications as one of the best lawyers in America. He has been in Huntsville and tried several cases. In fact, I get a little frustrated as a local trial lawyer because he seems to come up here and show up in cases that I think I ought to have. You know what I mean? But anyway, it will be a pleasure and a learning experience for us to hear Steve Henniger.
Good evening. It's a pleasure to be in Huntsville and facing the People's Law School instead of a jury. My topic tonight is bad faith, and that has to do with insurance. I will start by talking about something probably each and every one of you has been engaged in at some point in your lives, and that is filling out an application for insurance. Several years ago, an agent went to see a man to sell him some health insurance. They went over the application and the agent said, I'm going to leave this with you. You need to fill it out truthfully, accurately, and then I'll pick it up and we'll send it into the insurance company to see if we can get you insured. He said thanks, took it home. That night he started filling it out. It was very easy: name, social security number, address. Have you ever had any of the following diseases? No, he'd been very healthy. But then he got down to a block where it said names of parents, and if they are deceased, what they died from. His father was dead. His father had died in a hangman's noose in the state of Texas because he'd been convicted of cattle rustling. He was embarrassed by this fact. He didn't want it known. No one knew it but him. But he knew if he didn't answer the application honestly, what if he ever had a claim, the insurance company would come back and say, hey, you didn't answer this application honestly, so we're not going to pay your claim. And he just had a dilemma. So the next morning, on the way to the insurance agent's office, he stopped by to see his lawyer. And he told him of his dilemma and said, what am I going to do? I've got to answer this honestly. Because if I have a claim and they find out I've been dishonest, they'll deny my claim. But I'm embarrassed to put it, and I don't want anybody to know how he died. What do I do, lawyer? Lawyer thought for a moment, and he said, answer it honestly, but carefully. And so he turned in his application, and this is how it read. My father died while attending a public function when a platform collapsed. Absolutely honest and careful. I am a plaintiff's lawyer, primarily. And I'm here to talk to you about insurance matters, and specifically a remedy at civil law that is called bad faith. Now, I stand before you tonight, as I would before any group, and tell you that even though I'm a plaintiff's lawyer, I recognize insurance is a necessity from both a social and an economic standpoint. It follows each of us from the cradle to the grave. We all are encouraged by parents, by colleagues, and by commercials to plan for the future, plan for possible losses, and plan for financial security. And the vehicle that has been created to enable us to do that is called insurance. And all insurance is an offer by a company to accept the possibility of risk for each of us. If you ever have a fire or a health claim or in the event of your inevitable death, we'll be there. But only if you pass our qualifications, we accept your risk, and you pay the premiums. And then a contract is formed, and it's called a policy. We are encouraged so much by commercials that show families, neighborhood agents, and encourage us to plan for these losses and to put it in our hands along with your premiums, and we'll take care of you if it happens. We hope it never does. We sure do. But if it does, we'll be there. Now, in the insurance sphere, there are primarily three areas. The first is the agent. The second is the underwriter. And the third is the claims adjuster. Now, the agent sometimes works for the insurance company, sometimes is an independent agent, works for several insurance companies. But his or her job is to sell insurance. They make commissions selling insurance. They take applications and they forward them to the insurance company. Once the insurance company receives the application, the underwriter steps in. And the underwriter's job is to look at the application. How did your father die? How many diseases have you had? What kind of property is being insured? And to decide based on not just you as an individual, but on their experience actuarially, statistically. What are the chances that this person will have a claim? And then the premiums are based on those chances. Past experiences, loss ratios, and things like that. So the underwriter says, thumbs up. We accept this applicant. We will issue a policy. Policy goes out. You get it in the mail. You don't read it. You put it up and hope you never need it. And you get a bill once a month. You gladly pay it, but hope you never need it. But then the day comes when the third part may kick in, and that is the claims procedure. When it has happened, what you had tried to plan for has occurred, and you file a claim. And this is the sphere in which bad faith applies. Bad faith, unlike a lot of other legal terms, is plainly and simply what it says. Every contract of insurance has the inherent promise, whether it's spelled out or not in fine print, it's there by law, that the parties will act towards each other in good faith. They won't do something to deceive the other, like when you fill out the application. You should be acting in good faith with your agent, answering questions carefully and honestly so that they can evaluate the risk. Once they accept the risk and your premiums, they have the obligation as an insurance company to act in good faith, not to elevate their interests above yours, not to elevate the financial security of the insurance company above yours, not to deny valid claims and not to pay invalid claims. Because if they deny a valid claim, they've broken their promise. And if they pay invalid claims fraudulent claims, something like that, they harm the rest of us who are policy holders. So there's good faith, and there must be judgment. By far, most of the insurance companies in this country are responsible and fair. But ladies and gentlemen, we all know that in any industry there will be companies or people who try to take advantage for their own financial advantage. And this is where bad faith also comes into play, to protect claimants from being treated unfairly. Now, the insurance policies that I'm going to be referring to tonight are life, health, property, and underinsured or uninsured motorist coverage primarily, because these are the areas where bad faith arises. When I talk to you tonight, I'm talking about something, this is going to sound somewhat legalistic. It's called first-party bad faith. And that's the only kind of bad faith we have in Alabama. What that means is the only suit that can be brought, not just for breach of contract, if I file a claim with my insurance company, and it's a valid claim, and they refuse to pay me, I can sue them for breach of contract. Look, I did my part, I paid. I've given you a valid claim, you've breached our contract. And then there is more. If the breaching of that contract has been done intentionally, with malice, wanting to avoid a claim that's known to be valid, not mistaken, but known to be valid, then there's bad faith. But there's only first-party bad faith. I can sue my insurance company for the way they deal with me. I cannot sue someone else's insurance company for the way they deal with me. That's called third party. We only have first party, me and the insurance company. An example of third party would be, I'm stopped at a red light on my way home, and some idiot with 6 beers in his belly and with a lot of other things on his mind besides driving slams into the rear of me. And he really crunches up my car. And I've only had it for 2 days. And I'm not happy. So I call, after he gives me his insurance company's name, I call his insurance company and I say, are y'all going to fix my car? And they say, yeah, we probably will. We'll get back to you. And they don't. And I send them what they need. I have estimates done. They don't get back. Weeks turn into months. Finally go see a lawyer and I say, I don't understand it. This guy has insurance. I talked to them. They said they were going to pay my claim and now they won't. What can I do? You cannot sue somebody else's insurance company. Can't do it. You can only sue your own insurance company. Now there's a lawsuit against the man who hit me from the rear, and his insurance company defends him and may pay the claim, but I can't sue them in court. I can't bring them to a jury and say, why have they refused this? I didn't pay them any premiums. He paid the premiums. So my case would only be against my insurance company. And it goes across the board for those areas of insurance I've told you about. Life, health, property, and most of us probably have what we call uninsured motorist coverage. And that is, you want covered in case the guy who hit you from the rear didn't want to buy any insurance. He thought he would rather spend that money on beer than on premiums. And so you go out and buy insurance for him by putting it in your policy called uninsured motorist coverage. So it'll be there. But there, that's you paying the premium. So that would be a first party case that you might have. Now, in Alabama, the tort of bad faith, and tort is a word that lawyers use. Don't we have wonderful phrases that are so un-English? You know, y'all look at me like my dog does sometimes when he's saying, do what? Juries do the same thing. And ladies and gentlemen, this is a perfect example of the res gestae. And the jury goes, do what? And they should. But we spend a lot of money to go to law school to learn these long words that are absolutely useless. Tort is not a long word, but it sounds strange. A tort just means a civil wrong. Sometimes it can be exactly the same thing as a crime. An assault to someone is a crime. It can also be a civil wrong, where there is a suit brought for money damages for what was caused by the tort. Bad faith is a tort. It is a civil remedy that can be brought in the courts when an insurance company has acted in bad faith. This started in 1981. Many states had recognized it before Alabama did, but Alabama first recognized it in 81. And this is how they defined it. They said an actionable tort case arises for an insurer's intentional refusal to settle a direct claim where there is either, 1, no lawful basis for the refusal, coupled with actual knowledge of that fact, or 2, the intentional failure to determine whether or not there was any lawful basis for such refusal. So you can see that it has to be intentional, which can be very difficult to prove. It cannot be merely negligent. Mr. Henniger, we're sorry. We got your claim, but the adjuster put it in a stack, and his dog got sick, and he had to take the dog to the vet, and he was gone 4 months. And when he got back, he saw your claim and thought, oh gosh, I should have paid that. Meanwhile, I've been sued by the hospital for my bill. Negligence in handling a claim or not paying it is not bad faith. It's stupid and it's bad business, but it's not bad faith. The only time the state of Alabama will allow an insured to sit at one of these tables in front of a jury and a judge is if they can prove that the insurance company knew this was a valid claim or just didn't care, was just reckless, just decided, so what? So they have actual knowledge that it's a valid claim that should be paid. Or, if the claim comes in and they intentionally decide not to investigate it or to do something even worse, make things up in the investigation, create reasons to deny the claim when there is no valid reason to do so. So we have one part of bad faith is the intentional refusal to pay a valid claim with actual knowledge it's valid, or not even investigating it to see if it's valid. And if that's done recklessly, that's the same as doing it with knowledge. There's a third type of bad faith, and it's called bad faith failure to defend. When we pay for insurance, let me say, as an example, if I purchase automobile insurance through insurance company A, pay my premiums, and on my way home, I'm thinking about how I did at my speech tonight. I wonder if they liked me. I hope they liked me. I liked them. But you're on my mind instead of driving, and unfortunately, I run a red light and hit somebody, and I injure them. And guess what? They go see a lawyer. And that lawyer sends me an invitation to the courthouse. It's called a summons. And I tell my insurance company, look at what happened. I've been sued. What do I do? And the insurance company says, we told you we'd hire you a lawyer. And we will. We're going to hire Mr. Brinkley to be your lawyer. And then he is under an obligation to provide me a defense. He's my lawyer. He's not the insurance company's lawyer. He is my lawyer. They're paying for him, but he better be looking out for me instead of the insurance company. And if it's a case that needs to be settled, he should settle it. If it's a case that needs to be tried, he can try it. But he better be looking out for me, not just the insurance company. Because if he doesn't, or if the insurance company tells him not to, Alan just kind of put on a show. And we'll see what happens. And what happens is disaster. The jury says, lawyer, thinking about how wonderful he was while this group was looking at his shining, balding head, instead of thinking of what he should be driving. So we're going to hit him with a big verdict. And they hit me for a verdict that's more than my policy limits. I'm a little uncomfortable. And the insurance company had an opportunity to settle it for a lot less, but refused. And now says, deal with it. So there can be bad faith in the refusal to properly defend. Oftentimes, when there's a lawsuit in business or even in homeowners type policies, the insurance company says, we're not so sure we're liable. We're not so sure you have coverage because there's a special clause over here in the policy that's questionable, and we're going to question it. So they have to cross a bridge then. They have to decide, do we hire a lawyer for you if you've been sued? We promised we would, but there may not be any coverage. So what they may do is send what's called a reservation of rights letter. They write and say, Dear Mr. Hennigan, we've received those suit papers, but invited you to the courthouse, and we're aware of our promise. We know you've paid your premiums, but we're not sure. We're not sure we owe you a defense. But in the meantime, we're going to give you a defense while we think about it. So we don't want you prejudiced, but we'll give you a lawyer in the meantime. That's why they're reserving their rights to come back later and say, sorry, we don't owe you a defense. If they send a reservation of rights letter, that puts the lawyer they hire under what the law calls an enhanced duty. And this is why. Because what the law was seeing occur was that lawyers were having their first allegiance to whom? The hand that pays them. Insurance company. And oftentimes the insured would suffer in the end or during the middle. The insured wouldn't know what's going on, never get a phone call, never get a letter. What in the world's happening with my case since I gave my deposition? But the lawyer is sending report after report after report to the insurance company. So what the Supreme Court of Alabama said is, when you're defending under reservation of rights, make no mistake, lawyer, your client is the insured, not the company. You keep that insured informed. Let that insured know what the chance is of losing. If the judge is saying, I believe your client's going to get a big verdict against him or her, you better tell the client so they can get their ducks in a row to prepare in case what happens if I don't have enough insurance. So they'll know what's coming. And if that's not done, it can be bad faith. Now, we talked about the honesty in the application process. Let me go back to that. And if you'll indulge me, I think the best way to teach sometimes is by example, because some of this is so abstract, and so I'm going to give you some examples. These are real life examples. Only the names have been changed to protect the parties. These are cases I have been involved in, so that you will see that while most insurance companies are in fact responsible and fair, there are some out there that once in a while do things that need to be in court. Application time. Agent comes to the home of a couple selling health insurance. Wasn't called, wasn't asked to come, just showed up. Says, I've got this good policy. Better than the one you've got. And cheaper too. Two good things for thinking about. Here's the application, if you're interested. Sure, I'm interested. Okay, I'll fill it out while you tell me your answers. What's your name? Give name. When were you born? Have you ever had diabetes, high blood pressure, glaucoma, liver problems, stomach problems? No, 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 no. Down at the bottom it says, have you ever had a problem with alcohol? And the applicant says to the agent, yes, I am an alcoholic. I'm a reformed alcoholic. I went to a program 8 years ago. I haven't had a drink since, but I am an alcoholic, a reformed alcoholic. And the agent says, well, I don't think the company wants to know that. If you haven't had anything in 8 years, I'm going to answer no. He says, you're the agent. You work for them. She puts no. Application is sent in. 18 months later, he has a heart attack with no prior heart problems. $86,000 in medical bills. Sends in a claim form. Insurance company starts investigating. And they find out this guy was at an alcoholic rehab establishment 8 years ago. He didn't tell us that on the application. Dear Mr. Insured, appreciate your letter. Thank you for the bill. But it's yours. We don't owe it. You lied to us. But I told my agent. He calls the company. I told my agent, call her and ask her. So the adjuster, now we're at the claims adjuster at the home office, calls agent. Did he tell you? Yeah, he told me. Why did you put no? Because it was 8 years ago. Well, we're still not going to pay. So they don't. And it ends up in a court, just like this. What I've told you is the result of a lot of months of searching to go through the insurance company's files. Because when a claim is denied, the person whose claim it is doesn't know why, except for what's stated in the letter, or how that decision was arrived at, and you are very seldom given a detailed explanation. And so after a lawyer gets involved, ask for all documents. We ask for the entire claims file. I want to see everything. I want to see the memo that you were sending down the hall to him. And I want to see the memo that you were sending to the Vice President of Claims. Why was this claim denied? Because remember, we have to prove it was an intentional refusal to pay a valid claim. Now, in the scenario I've just given you, what do we have? We have an erroneous application, don't we? But the agent's the one that caused it. And the agent was acting for the insurance company. So when that agent says, I'm going to check no, that's the same thing as the president of the company saying it. There is no difference. And the applicant is entitled to rely on, well, you know better than I do. So then when it gets to the adjuster, and the adjuster says, but it's answered wrong. Well, that might be enough. But remember, after the insured called and said, talk to my agent, the adjuster calls, and the agent says, he did tell me that. So she has confirmed that she knew the truth, but put a falsehood. Now, who's to bear the burden for that? The law says the insurance company. But what did they do? They write back and say, we're still denying. And if you have a problem with that, you know where the courthouse is. And you know what? He did. And a jury had to resolve that issue. But that's an example of how an application can become involved in bad faith.
How much did you get?
No, I'm not going to talk about that. You see me afterwards. In the application process, there is a law in Alabama and in all other states that prevents what is called twisting. Twisting, what a nice word. What does it mean? It means it is illegal for an insurance agent to solicit a customer to drop one policy and take another policy when he or she knows that the one they're getting isn't as good as the one they're giving up. Why do they do it? Well, there's a commission involved. The commission rates, ladies and gentlemen, on something like life insurance are incredible. Maybe as high as 80% of the first year's premium. And so oftentimes you might wonder, why does the agent call me every 2 years and say, hey, Steve, we've got a new product that is even better, new and improved Tide. Well, of course, if I drop the other